On behalf of Jones Day, welcome to our program titled Joan Day's Tax Practice Presents a 4-Part Webinar Series, The 4 Acts of an IRS Controversy. Act 1, The Roadmap for Handling a Challenging IRS Examination. This program is scheduled to run from 12:15 until 1:15 p.m. Eastern Time. If you are having difficulty hearing me, please check to make sure that the volume on your computer is turned up all the way. If you have any other technical difficulties, contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you have not already downloaded a copy of the CLE Credit Information Sheet, you can do so from the Handouts tab on the left. The presentation has been approved for CLE credit for attendees. The CLE Credit Information Sheet provides you with information regarding the available credit. Applications for CLE credit in other states will be made as needed. Please keep in mind that CLE credit is not available when viewing the on-demand version of the webinar. There are several important steps that you must take to demonstrate that you are actively participating. First, each webinar participant listening from outside a Jones Day office must have registered individually for the webinar in order for your time of attendance to be recorded. If you have not individually registered for this webinar, please do so immediately by contacting Ashley McClung at 404-581-8910 or admcclung@jonesday.com. Second, at various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have up to a minute to confirm participation. If you do not confirm each time the box appears, you will be denied CLE credit. Third, you must be logged on for the entire presentation of the segment. Otherwise, CLE credit will be denied for that segment. Within 24 hours, you will receive a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory to enter your bar number. If you cannot locate your bar number, please contact the Beacon Live Help Desk for assistance. You will be in listen-only mode throughout the presentation. If at any time you have a question, you may submit them through the chat window located on the lower left corner of your screen. We will attempt to answer those questions at the end of the webinar. With the housekeeping out of the way, I will now turn it over to the live presentation.
Hello, welcome to the 4 Acts of an IRS Controversy. This is the first installment dealing with a challenging IRS audit. My name is Chuck Hodges, and I'm joined by 3 of my Jones Day colleagues from the tax group. First, in New York is Cathy Keneally, who focuses her practice on tax litigation and is one of the country's premier authorities on government investigations. Cathy is also a former Assistant Attorney General of the U.S. Department of Justice. Next, joining me here in Atlanta is Antoinette Ellison. Antoinette represents taxpayers in all tax controversies and litigation involving the IRS as well as state levels, and has handled U.S. tax court matters and U.S. district court matters, and has an expertise especially dealing with experts. And next, to provide some valuable insight, is Karl Kellar, who is in our D.C. office. Karl advises clients on international and domestic tax issues and the transactions associated with those. But prior to that, Karl was the acting director of the IRS APA and a former Department of Justice tax litigator. I'm Chuck Hodges, and I handle tax controversies and litigations and assist U.S. taxpayers facing tax disputes around the globe. So with that, we wanted to go quickly over the 4 acts of an IRS controversy. And we're going to do a webinar for each of these acts. For the Shakespearean followers, we don't have a 5th act, but hopefully you'll come up with a good question that will give us a 5th act. But the webinar for each act will build on each other and all around a theme that I hope you can pick up on, which is the proactive approach or proactive management of handling an IRS tax controversy. As you can see, the presenters all have tax litigation experience, so they have seen the full life cycle of a tax controversy matter. And while few cases go to court, and this presentation is not at all about audit issues we expect to go to trial, it's this proactive approach we will discuss that we borrow from litigation strategies. And that is from themes to IDR responses to document organization. It all kind of comes from the same type of strategies that litigators utilize when going to court. And we're going to apply these strategies for this proactive approach all the way back to the transactional stage of a matter. Why do we do this? And it's because this proactive approach is utilized. If you do it correctly, you derive efficiencies and your audit will go smoother. And if it does happen to go to appeals or even court, it's an easy transition because a theme has been crafted regardless of how many audit cycles you've gone through, and IDR responses have been prepared consistent with prior audit cycles as well as globally, and your current themes and positions are all secured. And especially, as you will see, your documents are well organized and you are actively managing the audit versus just being reactionary, which is what happens a lot of times in IRS audits, which is just answering the IRS and their requests. You know, taking again from like the play analogy, you have all the information and all the actors on which the plot is based. It's your documents, it's your tax return, your witnesses, your facts. You can and should proactively manage these items. For any other reason, it's ultimately your burden, whether at the exam, appeals, alternative dispute resolution, or court. The burden of proof rests on the taxpayer to prove the company is entitled to the tax consequences reported on the return. And then with the first returns filed after the TCJA enactment and all of its changes, and all of the public 10K disclosures regarding that, the amount of global data sharing among revenue departments, as well as the additional enforcement resources given to the IRS. And lastly, but cannot be ignored, a former tax litigator now serving as the current commissioner, we expect clients will need to be more proactive than ever when dealing with the IRS. So let's go ahead and jump into our agenda. And our agenda for today is, again, the 3 stages of an IRS audit, because an IRS audit actually involves 3 separate times, and that's the planning transactional stage, it's the audit stage, and then if you happen to agree to disagree, the unagreed stage. And we're going to go over all of the privileges that you need to be worried about, this proactive approach, the actual LB&I examination process, because you want to keep up to date on it. We're going to talk just briefly about LB&I campaigns. We all kind of thought that there would be more of a consistent message from the IRS that we could deal with those, but we haven't seen it yet, but we're still going to mention them since we're on our 7th wave of campaigns. Obviously, the transfer pricing roadmap is now gone, so we're going to talk about the new examination process for transfer pricing, and then the unagreed stage. And as you can see from the materials, there is a very thick appendix. When we first put these materials together, we had over 100 slides, and we realized that it was just impossible to cover in an hour. But we wanted, since many of you are friends of the firm, we wanted you to have the materials and no section things in there. Okay. And with that, we're now going to move on to the 3 stages of an IRS audit. And so the first stage, again, as we mentioned, is the planning and transaction stages, which is, and you need to appreciate that is part of the IRS process. And then, of course, you have the IRS audit, and then the unagreed stage. And so at this point, I want to turn it over to Karl and just simply start with this transaction stage and tee it up for Karl in this way. Karl, how can taxpayers proactively prepare for an IRS audit during the planning and execution of a transaction stage?
Well, thank you, Chuck. And I just want to reiterate or emphasize what you said. The best practice, even though it's not as common as we'd like sometimes, is to start thinking about preparing for the IRS audit even before you've done your transaction. And you know, when you said that that's the first stage of an audit, people might have scratched their heads and said, well, wait a minute, we haven't even done the transaction yet, but that's right. You want to think about and be proactive in what is the IRS going to do when you do this transaction. So I'm thinking about that in two ways. One thing, it's a cliche that tax lawyers complain that the business people don't bring them into the transaction until it's too late to change things. And as a tax lawyer, I urge you to bring tax lawyers in early, but that's not what we're talking about here. What we're talking about here is when you're planning a transaction, think about whether it's going to attract IRS scrutiny. Certainly, tax-driven transactions like a cost-sharing, offshore transfer is going to do that, but other transactions too, like exiting a foreign jurisdiction in a way that allows the U.S. parent to take a bad debt deduction, for example. You're going to get a big deduction there. The IRS is going to look at it. Or if for non-tax business reasons, has nothing to do with tax. It's not a tax planning play, but a foreign sub is going to lend money to the U.S. parent, or even maybe just pledge assets in support of a U.S. parent debt. Guess what? You're into Section 956, which is investment by foreign-controlled corporations into U.S. assets. So there's all sorts of things that can trigger an audit issue, and you want to think about them before you do it. So you want to put yourself in a position that you can proactively respond. What do you think about? You say, what can I do to shut down the IRS inquiry or to make them realize there's nothing to see here? Or if there is something to see here, how can I put it in the best light possible for me? Start building an audit file. Analyze your transaction from a tax perspective so you can anticipate the potential IRS attacks and have a response ready. Actually do your legal research and make sure that you've got a response to any potential IRS attack. Have memos or internal communications from the business people that explain the transaction in a non-tax, business-friendly way to show that it's a business necessity, it's not a tax play. Get press reports showing the business environment that will support your position. For example, we had a client that wanted to shut down its operations in a foreign jurisdiction and take a worthless stock deduction. So we helped them build a file of press reports that showed just how bad things were in that country and why it was a business necessity to get out of there. There's all sorts of things you can do like that, but you just need to think about it ahead of time. Finally, maybe the most important thing of all is to preserve your privileges. And we're lucky enough to have Cathy Keneally here, who's a world-class expert on that issue, so I'm going to throw it over to her to talk about preserving privileges during the transaction phase and later.
Well, thank you for that transition. Let me advance the slides. And thank you all for joining us. I started to think about the issue of privileges in a fairly hard way when a colleague of mine who left the government about the same time I did said, when we were in the government, we all thought that we could go to a company at the beginning of an examination and say, give me all your records, and expect everybody to be able to pull that together in a very efficient way and turn it right over. And that's not always how business operates. And we are living in an increasingly transparent world. As I'm sure everyone knows, there are tax authorities throughout the world that through things like BEPS and other things are requiring mandatory disclosure. And what you see from the IRS is exactly what my colleague said, which is when you begin an audit, when you begin an examination, that first document request that you get, the first IDR that you get, is asking that you pull together information fairly quickly so that there's a grounding of what went on. When you have a transaction that you know is going to draw attention, it is, to me, imperative that you think from the outset, as Karl was saying, how do I put all that information together so that I can put my best foot forward and either keep that transaction from being considered at any depth, explain it quickly, or at least have all the documentation ready to go to support the position. There are going to be things in there that you will want to keep privileged, that are confidential communications, that are the kinds of things that you might not want to give the government. And there are three areas where the privileges can protect you here. The attorney-client privilege, and I like to think about the attorney-client privilege as creating a space where the client can go through all of the possible permutations of a transaction, go through the client's concerns, review all of that which the client would not want anybody to know down the road once it all settles down, but all the thought processes and the things that might keep you up at night, the ways that you might have attempted to do something and decided against it, that whole legal analysis can and should be protected by the attorney-client privilege. But that is only going to work if you are considering the privilege from the outset. And as you'll see on the slide, the privilege protects confidential communications between an attorney and a client made for the purpose of obtaining legal advice. So the first element of the privilege is it has to be between the attorney and the client. The second is that it has to be for obtaining legal advice. And this is the first place where you need to think about how to segregate privileged information from non-privileged information. Very often lawyers become trusted advisors. They're also doing assisting on the business analysis. They're separately looking at something. Or there will be a document that's prepared that includes both the legal analysis and the business analysis. Business advice, business analysis is not privileged, and you're going to want to be thinking from the outset, how am I maintaining these records and creating these records so that I am segregating out and can clearly identify the privileged information. And then the third part, made and maintained in confidence, we could talk about it some length, but it is fundamentally that. And this is where early on, if you know you've got privileged communications, you want to think about who's in that privileged group, who's seeing that information, and make sure that you're keeping it confidential within the privilege. Now that privileged group is going to include, sorry, I'm clicking on the wrong box here. That privileged group is going to include anybody who either needs to be part of the discussion in order for the lawyer to understand what needs to be known to give the advice, or whoever needs to hear the advice. And you need to identify that, and this is where emails can be a plague. Everybody needs to understand not to be forwarding things, to be maintaining all of that. So the two questions that you ask yourself when you're looking at the privilege is, does the communication fall within what is a privileged communication, and are we keeping it confidential to the group that needs to be kept confidential? And from the outset, if you want to protect this information, then you want to make sure that you're clearly marking it, segregating it, and maintaining it in those ways. The second privilege that I want to mention here is what I'm sure some of you have heard from accounting firms and the accounting profession. They have a privilege that is similar to the attorney-client privilege. It is statutory, and it protects tax professionals who are giving advice. And again, if that's the nature of the advice that's coming, you want to, again, make sure that you're limiting it to the confidential group, you're maintaining it in confidence, and that you're clearly isolating that which is legal advice or tax advice, the analysis. The third privilege, which you should see on your screen, is the work product protection. This protection is different from the privilege in that it protects the actual work that the legal advisors do. 7525 that extends to the accounting profession does not include the work product protection. And the work product protection is very specifically intended to protect the work that a lawyer does from the adversary. So it differs from the privilege in that it allows the lawyer to do the work without, in a discovery process, in an IDR process, the government or any other adversary just lifting the work that the lawyer did. It only applies if you are anticipating litigation. Now, this is something that needs to be understood in the transactional stage, because the courts have held pretty consistently that tax controversy is litigation. So if you are anticipating that the IRS may come and challenge this transaction, even before you enter into the transaction, you can meet the work product standard that you are anticipating litigation. But at that point, what's going to be protected is the legal analysis that's done in the context of that transaction for the purpose of defending the transaction or explaining the transaction once the controversy begins. So that's where work product differs from the attorney-client privilege. I tend to think of all of this, and in the real-world context, you have a spectrum. And I began this discussion by saying we're in a world of global transparency, and there are things that are mandatory disclosures, and you know you're not going to protect. And then there are the things that are the things you most want to keep confidential, and that's where you want to make sure that you are thinking from the outset what is privileged, which privilege applies, and how you're protecting that information. One topic I want to break out separately here are documents that may be privileged when they are prepared, but you're either preparing those documents with the intention that someday you're going to present them to the government, or you make a decision down the road to present them to the government. The documents that fall into that category most obviously are tax opinion letters and transfer pricing reports, and that kind of work that may be done from the outset in a privileged way because you're seeking the legal advice or you're anticipating a controversy, but the documents themselves have a benefit to you if you provide them to the government. It is important to make a decision early on as to what you think you're going to do with those documents. If you're getting a legal opinion because you just genuinely want to know how the transaction works, that could be highly privileged and you want to protect it. If you're getting a legal opinion because you want to be able to show the IRS at some point that you did have a legal opinion in this transaction, then from the outset you need to think about that as something where it is either not privileged from the outset or the privilege is going to be waived. And you want to be careful to segregate that work from any privileged work that's being done so that you limit the waiver to that.
Thank you, Cathy. Oh, go ahead.
Well, one additional point I just wanted to mention before we moved off this is also if you are protecting from the outset, as I said, that it may be work product, the other thing you may want to consider is whether you need to put a litigation hold on everything. I know that when I say this to tax folks, everybody thinks this is fairly controversial. I assure you that your businesses have done it in other contexts, and it's another thing to consider in protecting the privilege, particularly the work product privilege, because when you are in anticipation of litigation, that standard is the same standard where courts will look to see if there's litigation hold. So that's another thing to make sure that you're considering. And yes, now I'm happy to transition this to go back to what I know is the rest of our discussion about considering being ready from the earliest stages.
Thanks, Cathy. And again, that all the privilege all fits into exactly what we're about to go over, which again is this proactive approach, which is, as you can see, is coordination and consistency, organization, and offensive strategy. And the privileges would fall under really all three of those bullets, but we're going to kind of go over these. Unfortunately, I couldn't come up with any good acronym because it's my understanding COO was already taken. So, but how does this come about? Here's a good example. I got a matter in last week where asked to prepare a protest for at the end of an exam or after an exam of which I was not involved in. So what was I given? I was given IDR responses from 2 audit cycles, and what I noticed was then asking for the documents that were compiled and given to the IRS. The thing that was interesting was that the IDR responses between the two audit cycles, they were prepared by different people. So there was an inconsistency that I found in some of the responses for the audit cycles. There was no real theme of the responses. Instead, it was simply responding to what was being asked by the IRS. And exactly what documents were turned over this 4-year audit was really unknown. And so that's really what we're trying to prevent, because as you can imagine, that situation, no matter how strong your legal case may be, that creates real inefficiencies. And from everything from, and it may get it to where you are getting to the next level, because when I read through the IDR responses, it kind of left me with the impression of, I see why the IRS would make the adjustment, because there was no proactive message of the case by the taxpayer. So that's really what this is. The proactive approach has coordination and consistency, organization, and offensive strategy. So let me touch on those briefly. The first one is the coordination and consistency. This one's really important because, as Cathy mentioned, we are having to disclose, the taxpayers are having to disclose information throughout the globe and to states. And and you have to be pretty transparent because it's all being shared. And so therefore, you have to coordinate and be consistent in your responses among audit cycles, among, if you're responding, on global audits in other countries, make sure, especially with transfer pricing issues, are you being consistent? And then, as we say there, you really do need the involvement of those that actually drafted the documents, as well as the tax department and any potential third parties. You have to kind of work together. And then, as we have you can't really prepare IDR responses in a vacuum. And so you have to instead, you have to make sure that every IDR response and everything that you do with the IRS from the opening conference, that you are consistently discussing your message. Going to organization, I think, especially as a litigator, this is my most important one, because there's nothing that can create inefficiencies more than a lack of organization. And it's very important in any intense audit or an audit cycles that go on for multiple years. And so what we do is we take the same thing that you would do in litigation and bring it back all the way to the beginning of the audit, which is you have one central location, you've got one document manager, which is usually a paralegal, and that helps with appeals and litigation because you can show what was shared and when. And now, I will say the last bullet is important, which is that it does need to be protected by the attorney-client privilege, or at least the way that I do it, and as well as, probably more importantly, the work product immunity that Cathy was discussing. So it's preferable that it's either created by or involving the attorney. But here is what I use, and here's just a PDF that we copied on top. This is what I have made for every IDR. It's an IDR response chart. And here it just tells, the date of the IDR, the IDR number, as well as the materials requested. And as you see, it's even got the custodian who has it, as well as the status, and redactions and privileges are mentioned. I will tell you before I get to the notes, the other thing that we do is, if you do have multiple audit cycles, you may be asked the same thing in the different audit cycles, but the IDRs may not be the same number. So you may have it to where IDR 10 in audit cycle 1 is now IDR 14 in 2. Well, that would be another column right next to this, which would let me know that, hey, make sure you refer back to those responses. Now, on the other end notes, I'm sure you guys, maybe some of you are looking and saying, okay, what on earth is Clemson and FSU? When you do a lot of work, especially in litigation, you have documents out among the table, and so I learned as a very young attorney that putting hot doc and this is a problem is not generally a good idea. So as a Clemson graduate, I use from time to time the word Clemson to identify documents that are sitting around that are helpful. unfortunately, I'm a Clemson, University of Florida, and Georgia Tech grad. So Florida State has never really been my friend. I apologize to all the Noles listening, but so I put that down. You guys kind of come up with your own thing, because I'll tell you it's helpful, because again, I have seen many people put down hot doc or problem, and you'd be surprised when you're sitting at the IRS with the IRS, and they can obviously see that upside down too. So you want to avoid that. But again, I highly advise this, because if you have turnover or anything, this response chart will walk you through, it can be picked up by anyone, and you can go forward. The next one is, okay, so now we're organized, now we're coordinated, but there has to be strategy. There has to be offensive strategy. Again, you cannot be reactionary when dealing with the IRS. And so we came up with about 25 strategies, but unfortunately we had to narrow it to only a few. Cathy here in a minute is going to talk about what I believe all of us know, Koval agreement, but we don't use enough. And then the second bullet is never give something for nothing. I would imagine if I asked most of you, what if the IRS asks for a statute extension, how often do you do it? And people are generally going to say, well, we do it all the time. And so, but you should ask to get something for that. In the sense of what I like to do is, if I say, okay, well, let me tell you this predicament I'm in, revenue agent, and that is you're asking for, and nowadays it's 14 more months. You've raised 2 issues, and I've informed my client of those 2 issues, but now you're asking for 14 more months. So what am I supposed to do as a professional if 3 months down the road you raise issue 3? Or, and I gave you more time. And so if you present it to the IRS in that way, it's not you being uncooperative. They are appreciating the fact that, wait, can we at least make sure that we're going to narrow it to these 2 issues? Or anytime the IRS says, look, I'm going to do a no change, but I've got a long admin process, so can you give me more time? Then I say yes. But my cover letter to them on that statute extension specifically states in the most lawyer language I can that here it is, but it's based upon you're getting the statute extension based upon the fact that we're getting a no change. The taxpayer is detrimentally relying upon that representation. Please respond to me in writing. Not just respond to me, but respond to me in writing if I have misunderstood anything. I would have that letter, folks, for anything where you're dealing with the IRS and they say something to you verbal, you have to send a letter back to them, and you have to say, this is my understanding of our conversation, and please tell me in writing if I misunderstood. That way, if it doesn't exist, it doesn't. And then I had this conversation a couple of days ago, which is walking through the IDRs. Revenue agent was a little surprised when I said, we have your draft IDR. I want to walk you through each one, and you tell me, really, what are you looking for? Because that was an effort to narrow the issues. So I highly advise that instead of just getting an IDR and letting it be reactionary.
Chuck, can I jump in just one comment on that? Because I've had a similar experience, and it's if you put it in the guise of being helpful to them, say, look, we've got 300 different agreements. You don't want to read them all. Can we just give you some samples, for example? I think that's been very helpful, and usually the IRS is responsive to that.
Exactly. And then the elevating the issues, I hope we're going to get to it, but we maybe not. But opening conference is, we all go to opening conferences, and the IRS is bringing a lot of people to them now. That's where you go ahead and discuss this proactive approach, and you do it in a very, cordial way where you set the groundwork for, hey, look, obviously I hope that we get along the whole time, but to the extent that I have an issue at all with the examination team, where do I turn? Who do I call here in the room? I'm sure there's not going to be a problem. Then it's all out on the front. Again, being proactive from the opening conference, because now you've laid the groundwork that you're not being rude. You're just simply going to proactively manage your audit. But now with that, I want to turn it over to Cathy, who's going to talk about the Koval and the preparation of new documents, the requests that the IRS sometimes does.
I'm going to touch very quickly on 2 of the things that Chuck just mentioned in his last discussion. United States v. Koval is a case that said that a lawyer understandably may not be able to do accountancy work. And that if a lawyer needs to give tax advice to a client, it needs to understand the work that an accountant would do. The lawyer can engage the accountant, and the accountant is then brought within the attorney-client privilege and the work product protection that the lawyer has. And I agree with Chuck that this can be a very valuable tool in getting ready for an IRS examination. The case law has extended it from accountants to all kinds of expertise, everything from economists, which we may see here, to media relations people, to all of that. The important thing to know about Koval is that the engagement needs to be between the lawyer and the expert, not between the taxpayer and the expert, not between the company and the expert, because the Koval expert is being brought in, the accountant is being brought in to assist the lawyer in giving that advice. Because that person is coming in within the privilege, it should be somebody who would otherwise fit within the privilege. So you generally do not bring in the return preparer or the audit firm or existing accountant relationships where there may already be an obligation to disclose. You want somebody who would otherwise fit within the privilege. But again, as Chuck said, that can be a very valuable tool. The only other point I'm going to make quickly so that we can move on here is to follow up on something that Chuck said. When the IRS asks for information, you are required to give them the documents that you have, show them the books and the records, answer their questions. You are not required to create evidence for them. So even if their IDR request or their summons says, prepare a chart, give us this analysis, you're not obligated to do that. There are circumstances where you may want to because it will take an issue off the table. I recently had a fairly complicated examination where we literally went through and put pencil notes and tied things out so that it would move more efficiently and they could just walk through the documents and understand how they all tied together. But you're not required to do that, and that's significant. And finally,
Cathy, we just got a note that they can't hear you.
Yeah, can everybody hear me?
Yeah, we're back in now.
Okay. Well, I don't know where I lost people, but I'm going to just keep moving forward. The summary point here is before we move on to what to do when the audit hits, and I'm going to turn it over to Antoinette so that she can talk about specifically how to handle an LB&I examination, which is what most everybody's going to see, is just to emphasize again, is to think about things even as you're doing the transaction as early in the process as possible so that you're ready to go.
So turning to the LB&I examination process, thank you, Cathy, and continue with the discussion about taking a proactive approach and the best practices for audit. In my experience, it is helpful to know the LB&I examination process, what's also referred to as the LEP for short, and to find ways to use the process to your advantage during the course of an audit. It is often harder to take a proactive approach when you are not familiar with the process and don't know the steps to take if an examiner for some reason is not following the rules. In the interest of time, I will run through these next few slides on the background leading up to the LEP. I'll just say that historically, LB&I devoted most of its resources to examining the largest taxpayers, which tended to be corporations within the Coordinated Industry Case or the CIC program. Local agents assigned to those audits determined the issues to be examined. Given this focus, LB&I had limited visibility in what's known as the middle market. And I'm sure we're all pretty familiar as well with the challenges that the IRS has faced since 2010. As its budget and workforce have declined, its responsibilities have increased, most recently dealing with the TCJA and putting out regulations and taking other steps to implement the Act. These factors have left the IRS under-resourced to perform its duties. Last slide on the background is that as part of the IRS trying to respond to its limited resources and put them to better use, it underwent a reorganization in February of 2016. Among other things, its resources were realigned among practice areas, 5 of them being substantive, 4 being geographic, and more importantly, there was a shift from focusing on taxpayers to audits that focus on issues. So now we're up to the point of the LEP. As part of the move to issue-based examinations, LB&I updated its procedures by releasing the LEP in 2016. So at the outset, I said it's a helpful tool and it's good to know the process. As noted in the last 2 bullets, the LEP identifies the roles and responsibilities for LB&I exam teams. And then also the Internal Revenue Manual contains more details about exams roles and responsibilities. There are sections of the manual dedicated to the various stages of the examination process. And the IRS is required to discuss the LEP with taxpayers during the opening conference, but I often think that you shouldn't wait until then. Once notified of an audit, it's a good practice to start familiarizing yourself with the rules that are going to govern the process. Just a quick point on this slide is that we know the IRS is under-resourced. They're wanting taxpayers to help them, and so there's a focus on transparency and cooperating in a spirit of responsiveness. The point is to just be careful in communications with the IRS. Of course, you need to communicate to try to resolve issues, but make sure you have the right people speaking, taking the proactive approach, make sure you're consistently getting your theme across, that you have a single point of contact if possible, and to keep a record of what is provided. All of this helps with the consistency and the organization that Chuck just discussed not too long ago. So additional point on the process, it divides audits into 3 phases: planning, execution, and resolution. Each phase has an overall purpose, and there are key factors. For purposes of this discussion, it's important to note that each phase has a section of the manual with information that taxpayers can use to better prepare for and manage audits. So for example, section 4.46.3, which relates only to the planning stage, discusses the preliminary risk analysis of issues identified for examination that exam performs before contacting a taxpayer for audit. And the LEP lays out the exact process that exam goes through, including the internal and the external sources that they consult, and it provides that taxpayers have a right to receive the preliminary risk analysis in advance. So it's important to ask for that analysis early on in the process. As Cathy mentioned, oftentimes documents, once an audit gets going, are requested and there's a short time to respond, and I'm sure we're all familiar with the new IDR directive and that the old rules where you could ask for extensions have been changed. And so getting this preliminary risk analysis early is a good way to know what issues the IRS is looking at, to start identifying key personnel, to start looking for documents and information, and start gathering all the information you will need to defend the positions taken on return as early as possible. There are also sample agendas and other sample documents that are in the manual, and it's important to consult those and to make sure that exam is using those throughout the course of an examination. And I think that this could even be used not only in exam but early on, because as Karl noted, it's important to conduct an analysis of a transaction, and you can sort of look at the steps that the IRS goes through and take those same steps yourself. But in addition to knowing the process, it's important to know the issues that the IRS is focusing on as well. And so at this point, I will turn it over to Karl to discuss the recent waves of LB&I campaigns.
Okay, thank you, Antoinette. Let's move forward. So we're going to cover this really quickly. We're running short on time, and we want to be able to try to cover everything at least a little bit. The important takeaway here is that as of a couple of years ago, the IRS announced that they were going to have compliance campaigns where they would identify specific issues that they would focus on. They've so far had 7 waves of compliance campaigns, and they've identified some 50 issues. And we obviously don't have time to talk about those now, but if you look in your appendix in the materials, you will see that we've listed all the different issues. So the important takeaway here is just look at this before you do a transaction to see if your transaction is going to be on it, and if it is, there's even more reason to be proactive, like we were talking about, because it's more likely the IRS is going to scrutinize it. Okay, so let's talk about the transfer pricing process real quickly. And again, I'm going to try to just breeze through this very quickly, but the reason that we identify this is because transfer pricing cases tend to be the largest dollar and the most resource-intensive audits that the IRS does. They can also consume a lot of your tax and compliance resources, and obviously we're talking about adjustments in the hundreds of millions, if not billions of dollars. So these are very important issues. Query whether they'll consume quite as many resources in the future, and the reason I say that is because with the Tax Cut and Jobs Act, they've changed the way that international tax is done. I'm sure you're all familiar with that. It used to be all or nothing. You move your IP offshore, you pay a 0 rate on it if you're successful, and if you lose, you pay 35% rate on it. Now it's not quite as big of a deal because you're at a 21% rate, and with the new GILTI tax, you're going to be paying 10.5% anyway. But still, 10.5% is nothing to sneeze at. A 10.5% difference in your tax rate is nothing to sneeze at. So it's still likely there's going to be transfer pricing issues being raised by the IRS. The other thing I just wanted to say about this is that the IRS has published its transfer pricing process. You can look at it. It's replaced the old transfer pricing roadmap. There's not a whole lot to discuss here in the limited time we have. One thing that I do want to mention is on the next slide that they've eliminated the need to have an initial transfer pricing documentation IDR for all international cases, and that's probably good. It's not always necessary, but that doesn't mean you shouldn't be doing your transfer pricing documentation. It serves 2 very important purposes. The one that everyone thinks of is it can give you penalty protection in case there is a transfer pricing adjustment. You're insulated from penalties as long as you have adequate documentation. But really the more important, in my mind, is that a robust, well-reasoned documentation, not a boilerplate cut and paste job, but a real documentation that analyzes the issues, gives you the opportunity to shape the issue and to put your position in the best light. Again, we're talking about being proactive. You can tell the story in the way that's most advantageous to you and your legal position. And I've actually seen when the IRS was looking at transfer pricing and they got a really good set of documentation, they just backed off and said, okay, we don't need to do a transfer pricing audit on this in this cycle. So it's something to think about doing. But that doesn't happen too often, though. Usually when you've got a big dollar case, you're going to be unagreed. And if that's the case, I'm going to turn it over to Chuck and let him talk about what you do with an unagreed case.
Thanks, Karl. And, one quick point on something that Karl and Antoinette both said, where have you noticed that, in the LB&I exam process, as well as the transfer pricing process, they both talk about transparency, and it is, all of us kind of take that as we as taxpayers have to be transparent. But if you really dig deep down into what the LB&I process as well as the transfer pricing process is really getting at is the IRS is now not only can you invite them to be transparent, you can actually demand them to be transparent. So they need to be transparent with you as you go along throughout the audit. It's real easy to simply, when they call up, to ask a question, and you simply say, "How's it going?" So what's going on with the exam as far as what we provided to you, and try to figure out where are they headed. because that will allow you to know better how to adjust maybe the way you're responding to IDRs, or are you dealing with somebody whose mind, and this is really important, somebody whose mind is made up but needs you to complete their file, because that to me is always an issue that I bring up, which is when they tell me that, look, we're about to issue you the NOPA, but we need another 1,000 documents from you just to finish our audit. That can be a problem, and you need to be very open with it. But anyway, now we're getting to the unagreed stage of the audit. So now we've gone through the audit. We know that we're agreeing to disagreeing. And as you see there, you need to preserve your record on appeal. Again, in a few months, we're going to have the appeals discussion, which I invite you to join. Because the one thing about appeals that's changed definitely over the last couple of years is the inability to bring up at appeals things that were not brought up at exam. And so that's why the organization is so important that we talked about. But before we get to that, the one thing is elevation of an issue. Are you dealing with an examiner, because you are somewhat unagreed on something? Do you need to elevate an issue to the manager or even beyond, based on what the examiner is doing? Another one, there are differences of opinion on how to deal with an acknowledgement of facts IDR. Antoinette's going to talk briefly about that. And then what you need from the examiner at the end of an unagreed audit. For example, the things that you may need that will help you minimize the issues at appeals. And then, of course, should you resolve any issues before going to appeals? The one thing to think about is if there are a couple of issues that you would probably concede anyway, but you're going forward with others, do you go ahead and concede those now, or do you go ahead and let them be written up too and go ahead and agree to everything with the appeals? So, and then again, as I mentioned, when to agree to disagree. But for now, I'm going to turn it over to Antoinette, and we'll talk about the acknowledgement of facts IDR, which comes at the end of the exam.
Okay, so we will now move to slide 40. So as Chuck, at the end of the execution phase of the examination, we now have this new process. It's relatively recent, and it's an important shift in LB&I audits. In the past, we had cases where the facts were not fully developed. We didn't agree on them yet. Yet we still filed a protest and proceeded to appeals. We also had cases where we presented new evidence to the appeals hearing officer. But now, when it seems like an issue will be unagreed, issue team members must seek the taxpayer's acknowledgement of all relevant facts of the issue through an AOF or acknowledgement of facts IDR. As noted here, this process relates to the Appeals Judicial Approach and Culture Project, which basically emphasizes the quasi-judicial nature of appeals. It says that appeals officers are not investigators or examiners, and more importantly, appeals will generally return cases to exam when a taxpayer submits new information or evidence, which is any item or document relevant to an issue that was not previously shared with exam and merits additional analysis or investigative action by exam. So a few questions here relating to responding to the AOF IDR. The first question is simply whether to respond at all. An issue team cannot compel a taxpayer to respond. There's a pro forma AOF IDR in the manual, and it specifies that it is not subject to the IDR enforcement process. But the form goes on to note that the lack of response will be mentioned when the NOPA or Form 5701 is issued. So there is a risk that refusing to respond could negatively affect settlement once a case is in appeals. So, for example, the appeals officer could simply conclude that the issues team's version of the facts listed in the AOF RDR are correct. The next question is when to respond. The first bullet point is pretty self-explanatory. With respect to the second, we've seen cases where an issue team has issued the IDR before providing a clear explanation of the legal basis for disallowing a position. In that instance, it's pretty hard to know whether or not all the relevant facts have been identified for the issue if you don't know the team's theory and the law that they applied in disallowing the position. So sort of when is after you make sure you have a clear understanding of the IRS's legal position. With respect to how to respond, the form itself sets forth 4 possible options. The first is to agree that all the relevant facts are documented. The second is to dispute specific facts documented. The third is to disagree that all relevant facts are documented. And there's a fourth that simply says other. General practice, we advise against responding to number 1. I think even in cases where the issue isn't very complicated or you would think that you should be able to agree to the facts, we find it preferable to go for option either 2 and or 3. So if you assume a situation where the issue team provides an AOF IDR and there are sort of 10 facts included, but you dispute, say, fact number 9 and number 10, and you think that there are 5 more additional facts that should be included, this is a good opportunity to go ahead and dispute facts 9 and 10 and make sure you draft your own response that includes those 5 additional facts. The issue manager must consider all facts, including disputed facts and additional facts provided by a taxpayer before signing off and issuing the NOPA. And so, though it doesn't happen often, there is a chance that once those disputed and additional facts are reviewed by the issue manager, there could be some movement on an issue. Another thing is holding facts until after protesting to appeals. You run the risk of being back before exam in the first or in the end ultimately, so it doesn't hurt to go ahead and provide those facts. Quickly, some best practices: make sure facts, no legal arguments, try if possible to exclude any characterization of the facts, and then as the last bullet, it may be beneficial to just include a statement in a response that reserves the right to rely on additional relevant facts not in the IDR in the case of a good faith error omission or further investigation or any changes in the IRS's theory of adjustment. So we will now move. We have a few minutes left. I think Cathy has taken over, and we're now going to move to elevating issues above examination team.
I'm going to touch on this very quickly given the time left. The bottom line message here, I think, is something that Chuck said earlier. He said that you've got the right to get information from them as well as to give information. It's a two-way process, and routinely you're going to have a team that comes that's looking at various issues and experts within the IRS and lay out a strategy at the beginning. And throughout the process, you have the ability to go find somebody else who, beyond the exam team, who may weigh in and straighten out some misunderstanding that's happening, some issue you want to elevate, something that you want to address. There's a lot of examples of when and how you can do this, and there's always sensitivity. You certainly want to maintain the relationship that you have, particularly if you're a taxpayer under continuing audit, with your exam team. But there will be times when you want to go find somebody else in the IRS, and I think all of us on this call have done it with good results, to find somebody else within the IRS and say, we need a specific issue addressed here. We've somehow gotten off track. We're not getting heard on an issue that we need to have heard. The one other less commonly used avenue that I wanted to mention, because I've seen it have great success, is that if all else fails, you can elevate something to the Taxpayer Advocate Service. I think everybody thinks of the Taxpayer Advocate Service as addressing the issues of low-income taxpayers and individuals, but I've certainly gone to them with very good effect where there's some systemic issue that is just not being addressed right, sometimes on behalf of a group of taxpayers where they need to address something. So I think that is as much time as we have to discuss that topic. And I guess, Chuck, I'll turn it back to you to wrap up.
Well, yeah, no, I think Antoinette has maybe one more point on the elevating issue, and then, yep, we'll wrap it up.
I think Cathy sort of touched on it in the fact that there is sensitivity, but as sort of the first slide on the point of why, and I'm sure we all understand, you have a right to do so, and if there's a way to do so without necessarily harming the relationship with the exam team. There were a number of scenarios that were included in the slides, and as Cathy mentioned, we don't have time to go through them. Just on slide 45, there are some that deal with the execution phase. This is where we often find issues that we have to elevate in dealing with IDRs. And then recently with the new AOF IDR, it was unclear before the new pro forma form and the manual was updated in December at the end of last year. And so we've had success in this area, elevating issues up to the issue manager and getting some traction.
Yeah. And again, as we discussed earlier, if you, in the opening conference in a very nice, cordial way, say, I'm sure it's all going to go well, but just in case we have any issues, who do I elevate to? And then that way they just, the agent is aware of it, and you said it in a cordial way to where they are at least understanding that you may do it. So that we are out of time, and so I would leave you really with a couple of things. One, please, if you have any questions about the things we hit, as well as in the appendix. I mean, we included things such as how important data privacy rights now are and how they impact IRS audits. That's in the back, as well as all of the issues that we touched on. Many of you are friends of the firm. Please reach out to any of us with questions directly. Our email and phone numbers are in our bios. But and of course, please join us when we do the appeals webinar in a few months. But as to this one, again, just leaving you with, we're trying, you want to set forth early on, even in the transaction stage, this proactive management of dealing with the IRS. And it's the consistency and coordination, it's the organization, and then, of course, taking advantage of offensive strategies, not always being defensive. And remember, how you can justify your actions is that everything coming out of LB&I right now says that the IRS and the taxpayer need to be transparent. So that allows you to be proactive. And again, you have the burden, so you should be proactive. This will minimize your efficiencies, and it'll definitely help you deal with appeals if you're organized and your themes are all in there to help you deal with appeals, who obviously deals with a hazards of litigation standard. But with that, thank you guys for joining us, and we look forward to speaking to you when we do the appeals presentation.
Thank you. If you want to ask a question still, you can enter it via the web presentation by selecting the chat pod located in the lower left corner of your screen, then typing your question and pressing the send button. All questions will be open. You can ask them in the next few minutes, and they will be answered offline. Thanks to our presenters for an excellent presentation, and a special thanks to everyone in the audience. If you meet all of the criteria to receive CLE credit, you will receive an email within 24 hours. If you do not receive the email, please contact Beacon Live. Goodbye.